Good afternoon, everybody, and welcome to General Laws. Clerk, if you'll open the roll for attendance. All right. Clerk, close the roll.
Madam Vice Chair, you can vote.
Madam Chair or Madam Vice Chair?
I don't have anything on here.
She's locked out.
She's locked out.
Locked out.
Just good. And how about Tran? How about Tran?
Tracy's not here.
Okay. Blank screen there.
Sherlock.
She has another bill she's presenting.
That's just like the ones before. Quick, Kathy. Hey, Charlie.
There we go.
Kathy.
All right, very good. Clerk, close the roll. We have a quorum present, and for Delegate Carr, your constituents can rest assured that you were not playing hooky from committee. We wouldn't want that to be left in there for posterity. I just want to make a really quick note before we begin, because we are starting to come through to the end of the first half of the session, and so we have crossover that's looming. And so this is just a quick friendly message that I'm also relaying on to my subcommittee chairs today. We only have a limited number of meetings left, and we do have quite a few bills left to be considered. And so for those of you who need your bills to go by for the day, we will grant that right, but I want everybody to be fairly warned that by the end of the day, if we run out of time on that last day, you do run the risk that your bill will be left in committee. We will not be meeting on weekends. My esteemed clerk asked if we would ever consider that, and then he went ahead and said, by the way, we haven't done that for a long time, and that would probably not want to be the signal you would leave to make, Mr. Chairman, right? I said, yes, correct. So again, if you need your bill to go by for the day, we'll be happy to do so, but know that you will go ahead and take on that risk. We have a number of administrative actions, and so our first one, Delegate Aird's House Bill 756. She has asked that we strike that bill, and that is a recorded vote. It's been properly moved and seconded. Clerk, open the roll. All right, clerk, close the roll. House Bill 756 is struck from the docket on a 21-0 vote. Our next one is House Bill 833. Delegate Carol Foy. There has been a request to refer that to Labor and Commerce.
So moved.
Do we have a second? All right, that's a voice vote. All those in favor say aye.
Aye.
All those opposed. That bill is referred. Delegate Watts has asked that her bill, House Bill 1418, be passed by for the day, and so without objection, we will pass that by for the day. House Bill 1671, Delegate Wilt has asked that that bill be struck from the docket. Do I have a motion?
Second.
Okay. That is a recorded vote. Please indicate your vote on the electronic voting machine. Clerk, close the roll. That bill is struck from the docket 21-0. And finally, House Bill 1708, Delegate Tyler. We are going to carry that over to 2021 under Rule 22. That is a voice vote. We've properly moved and seconded. All those in favor say aye.
Aye.
All those opposed. All right. So we are going to switch the order of our subcommittee reports, and so we are going to start with professions, occupations, and administrative processes. And so I'm going to turn it over to Delegate Hurst. Delegate Hurst, your report, please.
Thank you, Mr. Chairman. Appreciate the accommodation for me. That's the reason why we are taking the subcommittee report out of order. So starting on page 6 of your agenda, members of the committee, there are three bills now that have reported out uncontested that if it be the will of the committee, we report in block. We have amendments that we'll get to later for House Bill 1431. So Starting first, Mr. Chairman, members of the committee, House Bill 950, patroned by Delegate Ranson. It clarifies that a cemetery wholly owned and operated by a non-stock corporation, not operated for profit, is exempt from regulation by DPOR if, among other things, such corporation uses the proceeds from the sale of all graves and rights for the purpose, but not necessarily the sole purpose, of defraying direct expenses of maintaining the cemetery. There is a cemetery in her district, Historic Christ Church. It's a national landmark. They asked to have some of the proceeds also be used for historical educational resources and maintenance of the entire site. We reported that bill out of subcommittee with a substitute, a 7-0, and I would so move. Okay. House Bill 990.
If you'll hold up one moment, Delegate Hurst.
Sure.
So we have a substitute. Is there a motion for the substitute?
So moved.
Is there a second? All those in favor say aye. Aye. All those opposed? All right, Delegate Hurst.
All right, thank you, Mr. Chairman. Members of the committee, House Bill 990 from Delegate Reed moves the Department of Military Affairs from Public Safety and Homeland Security Secretariat to the Veterans and Defense Affairs Secretariat. It reported out of subcommittee by a vote of 8-0, and I would so move. And finally, in block, Mr. Chairman, members of the committee, House Bill 993 from Delegate Lindsay cleans up some language, aligns authorizing language across certain boards and councils, increases from 18 to 21 the non-legislative citizen members of the Asian Advisory Board and the Council on Women. It also removes the power and duty of the Council on Women to review and comment on budget and appropriation requests and grant applications. It revises the purpose of the Council on Women from identifying ways in which women can reach their potential to advising the governor or on matters of pertaining to women, and ways to improve rather their educational, professional, cultural, and governmental status within the Commonwealth. The subcommittee reported the bill 7-0, and I would so move.
All right.
And so those three bills, Mr. Chairman, if we could vote on those in block.
Okay, very good. Is there any member of the committee that wishes to take one of those bills out of the block? Hearing none, clerk open the roll. All right, clerk close the roll. Those bills report 21-0. Delegate Hurst.
Thank you, Mr. Chairman. Members of the committee, next up is House Bill 1431, patroned by Delegate Mugler, having to do with the Art and Architectural Review Board. There are line amendments that Council will need to report after we reported the bill out of Subcommittee 8-0.
Right. Council, can you report the line amendments?
Yes, Mr. Chairman. On line 26 of the introduced bill, after B, as in subsection B, strike the rest of line 26, all of line 27, and through the word thereafter on line 28, and insert following the initial staggering of terms, comma, citizen. The second line amendment after line 42 at the end of the bill, insert in its two enactment clauses. Number 2, that the term of the citizen member added to the Art and Architectural Review Board pursuant to this act shall be for a term of 4 years to begin July 1st, 2020. And 3, that the terms of the citizen members that are set to begin July 1st, 2022 shall be staggered as follows: 2 members for a term of 1 year, 1 member for a term of 2 years, and 2 members for terms of 3 years. Thereafter, members shall serve terms of 4 years.
All right, Delegate Mugler, would you like to explain the nature of your amendments?
Thank you, Mr. Chairman. Essentially, this bill was just to add additional members to the board, and as it was being looked at earlier, it was noticed that the staggering language was sort of convoluted, and so this line amendment addresses that.
Okay. Do any members have any questions of the patron? Is there anybody who wishes to speak to the amendments?
Mr. Chair, members of the committee, Sandra Gill, DGS. Thank you, Delegate Simon, for bringing it to our attention. Want to thank staff and the Secretary of the Commonwealth for working this language out, and we appreciate Delegate Mugler working with us through this.
Great. Thank you. All right. Do we have a motion on the amendments?
Move the amendments.
Second. Motioned and seconded. All those in favor say aye. Aye. All those opposed? All right, any further discussion on the measure? Hearing none. Clerk, open the roll.
Thank you very much.
Do we have a motion to report?
Move to report. Second. All right, we have a proper motion to report. All right, clerk will close the roll. That bill reports with amendments 21-0. Delegate Hurst.
Thank you, Mr. Chairman. Next up for the committee, House Bill 140, patroned by Delegate Davis. The subcommittee reported incorporating House Bill 140 into House Bill 757, and I would so move that incorporation.
Okay, that's been properly moved and seconded. That is a voice vote. All those in favor say aye.
Aye.
All those opposed? All right, House Bill 140 is incorporated. Delegate Hurst.
Thank you, Mr. Chairman. Members of the committee, next up is House Bill 757, patroned by Delegate Aird. It prohibits state agencies and localities from including on any employment application a question inquiring whether the prospective employee has ever been arrested for, charged with, or convicted of any crime. The subcommittee reported recommending with a substitute by a vote of 5-2, and I would so move.
Substitute?
All right. The substitute's been moved and seconded. All those in favor say aye.
Aye.
All those opposed? All right. Does any member have any questions? All right. Delegate Cole.
Just speaking on the bill, I think this bill may be well-intentioned, but it's actually, I think, going to create more harm than good. These agencies and localities should be able to ask this question if that's going to be a consideration on whether or not the person is employed. What happens when they ban the box is what this has been called, is they don't ask the question. They will go and make a tentative offer to somebody, and the offer will be contingent on passing a background check. And then if there is any criminal record comes back on the background check, they will withdraw the offer of employment. So all this does is waste the employer's time and the employee's time, and I hope that we would not report this legislation.
Delegate Aird.
Thank you, Mr. Chairman and members of the committee. I'd just like to remind Delegate Cole and members of the committee that this is actually current practice via executive order, and so this codifies what we are doing here in the state of Virginia, with the exception of the additional language we added to sensitive positions and localities. Thank you, Mr. Chairman.
All right. Anybody else wish to speak? All right, hearing none, has been properly moved and seconded. Clerk, open the roll. All right, clerk, close the roll. That bill reports with substitute on a 16-6 basis. Delegate Hurst.
Thank you, Mr. Chairman. Members of the committee, House Bill 982, patroned by Delegate Webert. There has been a request to pass that bill by for the day. And so, Mr. Chairman, if you could make that motion without objection.
Okay, without objection, we'll pass by House Bill 982 for the day.
Thank you, Mr. Chairman. Next for the committee, House Bill 1042, patroned by Delegate Herring, establishes the Virginia Council on Environmental Justice, consisting of 24 members, to advise the governor and provide recommendations intended to protect vulnerable communities from disproportionate impacts of pollution and provide such communities meaningful involvement in the decision-making process. The bill provides that 18 members of the council are appointed by the governor, 6 are specified cabinet secretaries. The subcommittee recommends reporting 6-2, and I so move.
Okay. Delegate Hurst, I believe we have a, nope, no substitute. All right, so it's been properly moved.
Actually,
Delegate Herring.
Mr. Chair, actually, there is an amendment in the nature of a substitute that the governor's office asked that be submitted.
Very good.
So,
Council, do you have substitute? Very good.
Mr. Chair, if you want me to wait, or you want me to go ahead and start explaining?
No, Delegate Herring, why don't you explain the substitute before we adopt it?
All right. So the substitute, I'll go through it slowly. On lines 22, you'll see there's a change. It said environmental decision, and it's providing more specific. It's more specific, and it would be resulting from an industrial, governmental, or commercial operation, program, or policy. Just so that it's a little bit more specific and not as vague. The next changes are lines 43 through 46. Again, providing more specification regarding non-legislative citizen members, and providing for representatives of the American Indian tribes, community-based organizations, the public health sector, non-governmental organizations, civil rights organizations, institutions of higher education, and communities impacted by industrial, governmental, or commercial operation programs or policies. The next change, Mr. Chair, line 51, instead of the government appointing the chair, it would be the council that will decide who will chair. And then, Mr. Chair, the other significant change is on lines 99 through 102, and regarding the initial appointments of the non-legislative citizens and the staggering of terms.
All right. Thank you, Delegate Herring. Does any member of the committee have a question of the patron?
Move adoption of the substitute.
All right. Is there a second? All right. All those in favor say aye.
Aye.
All those opposed? All right, so we have the substitute before us. Do any members of the committee have any questions of the patron? Or is there anybody from the audience who did not have a chance to speak in subcommittee on this bill? Delegate Morefield.
Mr. Chairman, thank you. Delegate Herring,
Yes.
just for clarification, was there any discussion on ensuring that there will be fair representation as far as geographic representation? I mean, I think from the members from Southwest and South Side, we obviously would like to see some members appointed to the council.
Right, so in the subcommittee, there was not that specific discussion, and I would imagine that would be, and then I do have someone from the administration, Mr. Chair, if she could address that.
Yes.
Mr. Chairman, Miriam Karad from the Governor's Office. There was discussion in the way in which we have written that portion about membership attains geographic representation by looking at the different represented groups. And that is also our policy. Currently, you'll note that we do have a Environmental Justice Council that represents the geographic areas as well. And one of the things that we also are doing through the Department of Environmental Quality is looking at the 6 regions that are represented there, and that's how we're moving forward there.
Delegate Morefield, you good? All right, Delegate Fowler.
Thank you, Mr. Chairman. I have a question for the patron.
Yes.
About the substitute. Line 18, we talk about environmental justice. You know, I'm in complete agreement with how we define environmental justice. Fair treatment, equitable consideration, meaningful involvement, all that's fantastic, that's great. We get over to line 36 and we talk about principles intended to protect, I'm sorry, I don't know if you can hear, vulnerable communities from disproportionate impacts of pollution. And so I'm not sure, how would you define disproportionate?
I'll defer to the administration.
Mr. Chairman, Delegate, so one of the ways in which we use that definition is through the EPA definition, and that is taken through policy as well.
Okay. Delegate Fowler, you good?
Can you repeat that again?
So some of the definition is taken from the environmental protections definitions on that matter, and one of the ways in which we discuss that is if it's disproportionately affecting one community over another, and there's details to that. But again, it is an ode to the EPA definition, and that's where we can find the source.
Right. Thank you.
Thank you.
Thank you,
Very
Mr.
good.
Chairman.
Anybody else? All right, we have a properly, it's been properly motioned to report. Clerk, open the roll. All right. Clerk, close the roll. That bill reports on a vote of 15 to 7. Thank you, Delegate
Mr. Chair.
Herring.
Thanks.
Delegate Hurst.
Thank you, Mr. Chairman. Up next are several bills that we recommended reporting and referring to the Committee on Appropriations. First, House Bill 581, patroned by Delegate Guzman, would require the Department of Human Resource Management to develop an online training module addressing lesbian, gay, bisexual, transgender, and queer cultural competency. The bill requires all state employees commencing or recommencing employment with the Commonwealth on or after January 1st, 2021 to complete such training within 90 days, and all persons who are recommencing such employment with the Commonwealth after that to complete it no later than April 1st, 2021. The subcommittee recommended reporting by a vote of 4 to 3 to report and refer to the Committee on Appropriations, and I so move.
All right. Do any members of the subcommittee wish to speak on House Bill 581? Is there anybody in the audience who did not have a chance to speak in the subcommittee? Seeing none, clerk, open the roll. Clerk, close the roll. That bill reports 14 to 7. Delegate Hurst.
Thank you, Mr. Chairman. Up next, House Bill 606 from Delegate Miaris. It directs the Department of Criminal Justice Services, under the direction of the board, to develop an online course to train hotel proprietors on recognizing the signs of human trafficking and how to respond appropriately. The bill also defines in code hotel and hotel proprietor. The subcommittee recommended reporting and referring to the Committee on Appropriations by a vote of 7 to 0, and I so move.
Okay. Do any members of the subcommittee or any members of the committee have any questions on the bill? Does any member of the audience who didn't have a chance to speak in subcommittee wish to speak? Hearing none, clerk, open the roll. All right, clerk, close the roll. That bill reports 22 to 0. Delegate Hurst.
Thank you, Mr. Chairman. Members of the committee, House Bill 935, patroned by Delegate Willett, eliminates the requirement that the governor provide a biannual report that includes information regarding grants and loans awarded from the Commonwealth's Development Opportunity Fund. The bill also clarifies the due dates for plans and reports to be prepared and submitted by the Virginia Economic Development Partnership Authority to various individuals, and repeals the requirement that the Secretary of Commerce and Trade provide an annual report on the effectiveness of economic development programs in the Commonwealth. It does not eliminate the reporting of specific information, just changes when and who will report such information. There was a substitute that the subcommittee recommended adopting and reporting, and then referring to the Committee on Appropriations by a vote of 8 to 0, and I would so move.
Okay, there is a substitute. Do I have a motion on the substitute? Do I have a second? All those in favor say aye.
Aye.
All is opposed. Does any member of the committee have a question? Delegate Leftwich.
So, Mr. Chairman, when I read this, it appeared as if it eliminated the need to submit that report to the respective chairmen of the Finance and Appropriations Committee for the House and the Senate. Is that still the case?
Delegate Hurst.
Mr. Chairman, Delegate Leftwich, I believe that is still the case from the Commonwealth's Development Opportunity Fund as it's currently written, yes.
Okay. Thank you.
Any further questions? All right. Anybody in the audience wish to speak who didn't have a chance to speak in subcommittee? All right. Hearing none, clerk, open the roll. All right. Clerk, close the roll. That bill reports 18 to 4. Delegate Hurst.
Thank you, Mr. Chairman, members of the committee. House Bill 1354, patroned by Delegate Plum, establishes in the executive branch of state government the Plastic Pollution Prevention Advisory Council to study and make recommendations regarding plastic pollution problems in the Commonwealth with the mission of eliminating plastic waste. The bill does have a sunset, June 30, 2023. There was a substitute. The subcommittee recommended adopting and reporting and then also referring to the Committee on Appropriations by a vote of 7-1, and I would so move.
Do we have a motion on the substitute?
Second.
There's a second. All those in favor say aye. Aye. All those opposed? Does any member of the committee have a question on House Bill 1354? Does any member of the audience who didn't have a chance to speak in subcommittee wish to speak on House Bill 1354? Hearing none, clerk open the roll. All right, clerk close the roll. That bill passes 16-6. Delegate Hurst.
Thank you, Mr. Chairman, members of the committee. House Bill 1424, patroned by Delegate Krizek, establishes the Virginia Revolutionary 250th Commission to plan, develop, and perform programs and activities to commemorate the 250th anniversary of the American Revolution, the Revolutionary War, and the independence of the United States. The bill has an expiration date of July 1st, 2027. The subcommittee recommends reporting and referring to appropriations by a vote of 8-0, and I so move.
All right, very good. No substitutes or amendments?
No, Mr. Chairman.
All right. Does any member of the committee have a question of the patron on this bill? It's a very fine bill. Does any member of the audience who did not have a chance to speak in subcommittee wish to speak on this bill? Seeing none, clerk open the roll. All right, clerk close the roll. That bill reports and refers to appropriations 22-0. Delegate Hurst.
Thank you, Mr. Chairman. House Bill 1519, patroned by Delegate McQuinn, creates the Commission to study slavery and subsequent de jure and de facto racial and economic discrimination against African Americans to, 1, study the current impact and long-term inequities of slavery and the subsequent state-sanctioned de jure and de facto racial and economic discrimination practiced against African Americans, and 2, make recommendations to the General Assembly on appropriate remedies. The bill requires the Commission to annually submit a report on its interim activity and work to the Governor and the General Assembly. The bill has an expiration date of July 1st, 2022. The subcommittee recommended reporting and referring to appropriations by a vote of 8-0, and I so move.
Second.
Very good. Does any member of the committee have any questions about House Bill 1519? Does any member of the audience who did not have a chance to speak in subcommittee wish to speak on House Bill 1519? And you did not have a chance to speak in subcommittee?
Not on this bill.
Very good. You have the floor.
My name is Talia Davenport Mallory, and I'm here with friends and members of the National Coalition of 100 Black Women, and we are in full support of the bill.
Great. Thank you very much. All right. It's been properly moved and seconded. Clerk, open the roll. All right. Clerk, close the roll. That bill reports and refers to appropriations on a 22-0 vote. Delegate Hurst.
Thank you, Mr. Chairman. Finally, out of the subcommittee report, we have one bill with a request to strike House Bill 28 from Delegate Lindsay, removing a provision enacted last year that currently allows only natural persons to be licensed as pawnbrokers. The subcommittee recommended striking from the docket by a 7-0 vote, and I would so move.
All right. There's a second. All right. Clerk, open the roll. Clerk, close the roll. That bill is struck from the docket on a 22-0 basis. Delegate Hurst, does that complete your report?
Yes, Mr. Chairman, that completes our report.
Perfect. Excellent job. Thank you very much. All right. Moving on to Housing and Consumer Protection. Delegate Simon.
Thank you, Mr. Chairman, members of the committee. The first thing we need to do on this, we have 7 bills that were incorporated into House Bill 1663, and I'm going to read the bill numbers out, and if we could, I think, vote those in a to incorporate those in a block, that'll be a voice vote. But just to tell everybody what we're doing, that's House Bill 3 from Delegate McQuinn, which made changes to Virginia's fair housing law. House Bill 21 from Delegate Lindsay, which prohibited certain types of discrimination on the basis of sexual orientation and gender identity through the Human Rights Act. House Bill 23 from Delegate Lindsay, prohibiting discrimination in public employment and housing. House Bill 217 from Delegate Converse Fowler, which prohibited discrimination on the basis of sexual orientation and gender identity in housing. House Bill 1050 from Delegate Levine, which covered public accommodations, employment, credit, and housing. House Bill 1200 from Delegate Tran, which again would have created causes of action for discrimination based on race, sex, pregnancy, childbirth, related medical conditions, etc. House Bill 1512 from Delegate McQuinn, again, which would have dealt with the discrimination based on pregnancy, childbirth, or related medical condition. And so I would move that those 7 bills be incorporated into House Bill 1663 in a block.
Okay, any discussion from the committee? Is a voice vote. All those in favor say aye. Aye. All those opposed. All right, Delegate Simon.
And we'll come back to House Bill 1663 as it's in a different part of the agenda, I think. So we're going to go to House Bill 7 from Delegate Bourne. House Bill 7 makes changes to Virginia's fair housing law regarding source of income. Prohibits any locality, or sorry, it's a little bit different. Let me tell you what it does. It prohibits any locality, its employees, or its appointed commissions from discriminating in the application of local land use ordinances or guidelines, or in the permitting of housing developments on the basis of race, color, religion, national origin, sex, elderliness, familial status, or handicap. And then we had a committee amendment, which I'll move in just a second, to add sexual orientation and gender identity. In permitting of housing developments, because the housing development contains or is expected to contain affordable housing units occupied or intended for occupancy by families or individuals with incomes at or below 80% of the median income of the area where the housing development is located. The bill also requires the Fair Housing Board, after determining the existence of a non-lawful discriminatory housing practice and after consultation with the Attorney General, to immediately refer the matter to the Attorney General for civil action. So first I move the committee amendment.
Okay, substitute?
No, it's just
It's a committee substitute.
It would turn out to be a committee substitute, so I first move the substitute.
Okay, is there a second?
Second.
Okay, all those in favor say aye. Aye. All those opposed? Okay.
And then the subcommittee recommended reporting the substitute 7-1, and so I now so move.
Okay. Is there any discussion by the committee? Are there any members of the audience who did not have a chance to speak in subcommittee that wish to speak on the bill? Hearing none, clerk, open the roll. All right, clerk, close the roll. That bill reports with a substitute, 17-4. Delegate Simon.
Mr. Chairman, members of the committee, House Bill 340 from Delegate Price. The committee recommended a series of line amendments, which you can see on page 5 of your agenda. And I guess I should probably go ahead and just move the line amendments.
All right, there's been a motion to move the line amendments. Is there a second?
Second.
Okay. All those in favor say aye.
Aye.
All those opposed? All right, Delegate Simon.
So what House Bill 340, Mr. Chairman, does is provides 30-day stay of eviction and foreclosure proceedings for tenants, homeowners, and owners who rent to a tenant a 1 to 4 family residential unit who request a stay to provide written proof, as defined in the bill, that they are an employee of the United States government or an independent contractor of the government or an employee of a company under contract with the United States government who was furloughed or is otherwise not receiving wages or payments as a result of a closure of the United States government as defined in the bill. So what the bill does is this is the shutdown law that says if you're a victim of a government shutdown and you can't afford to pay your rent or pay your mortgage, or your tenant can't pay their rent, so you can't pay your mortgage, you get a stay until the government reopens and starts paying those folks back. And then it states that what the line amendments do is add some time definition, some outside time limits on that. So the stay is 60 days for tenants.
Okay, very good. Does any member have any questions of the patron? Delegate Cole.
Yeah, I'm just trying to, I see a 30-day stay of eviction or foreclosure, and then the gentleman, when he was presenting the bill, said 60 or 90 days. Can you, can you just explain to me how many days for each situation the action will be stayed?
Delegate Price.
Yes, so for tenants, it's 60, and for the others, it's 30. The 90 days is just setting the timeline for the end of the furlough for 90 days that they could use this. So it's not a 90-day stay, it's a 90-day period after the end of the furlough. It's just 30 and 60 for the stay of action.
All right, thank you.
All right. Any other questions? Anybody in the audience who didn't have a chance to speak on this in subcommittee? All right, seeing none, clerk open the roll. All right, clerk close the roll. That bill reports 13-7. Delegate Simon.
Mr. Chairman, members of the committee, House Bill 1049, next on our list from Delegate Levine. What this bill does is sort of call this the SOGI bill as a shorthand. What it does is it adds discrimination based on sexual orientation or gender identity to the list of unlawful discriminatory housing practices throughout the code. So it has to go to every code section where folks are prohibited from discriminating on the current list of protected classes, race, religion, sexual, national. The whole list. I don't know the list off the top of my head, but add sexual orientation and gender identity at the end of that list. And the subcommittee recommends reporting that bill 7-1, and I so move.
Okay. Second. Does any member of the committee have any questions? We also have the patron here. All right. Seeing none, anybody from the audience who did not have a chance to speak in subcommittee? Seeing none, clerk open the roll. Clerk close the roll. All right, that bill reports 15-6. Delegate Simon.
Next bill is House Bill 1333 from Delegate Keem. And what this bill does is it requires that a landlord permit a tenant to provide damage insurance coverage meeting certain criteria in lieu of a payment of a security deposit. The bill caps the total amount of any combination of security deposit and rental insurance coverage required by the landlord to twice the amount of the periodic rent payment. So it requires that a landlord permit a tenant to provide damage insurance instead. So this is to deal with those cases if you've got a tenant who's strapped for cash and can't afford to put up a 2-month security deposit, but can afford an insurance premium that will provide the landlord with 2 months worth of payment to cover any damage that would be there when they move out. They can do that in lieu of a cash deposit. And the subcommittee recommended reporting that 7-0, and I so move.
Okay. And Delegate Simon, are there any outstanding moving parts, or is this? No.
Is there? It sounds like there's perhaps a committee substitute that the subcommittee didn't have, but is going to be looked at here in full committee.
Okay.
So I guess the clerk will distribute a substitute.
And I don't see Delegate Keem here, and so I don't know if council's in a position to explain what this does while we're handing it out.
They're handing it out.
Okay. I just want. I've already spoken.
Thank you.
All right, council. Thank you.
Thank you, Mr. Chairman. So the substitute adds a section, I believe it's 1206 or 1208. But what it does is it just conforms the language that says security deposit and damage insurance premiums, and it strikes premiums and says adds in coverage. But we had to add in a whole new section, which is why it's not a line amendment, but a substitute.
All right,
and that conforms it to the prior bill.
Okay. Delegate Simon.
So it sounds like this is just we found an error at subcommittee, and this was an permanent concept, which is why it wasn't a recommendation of the subcommittee. Where some places it was inappropriately using the word premium when we meant coverage. The idea is that there's got to be 2 months worth of coverage that is up to 2 months worth of the monthly rent, which is the same thing the security deposit would be. The premiums aren't that expensive. That's why you do it. So we just took out the word premium and put coverage where it was appropriate.
Okay, Delegate Fowler.
The question of the patron, Mr. Chairman.
I do not believe that the patron is here.
I'm happy to try and answer it.
Delegate Simon will give it his best attempt, and
if I can't,
we'll see if this needs to.
I thank the delegate. Delegate Simon, I'm curious about this insurance policy. Is this a policy that's provided by the landlord or by the tenant?
So, Delegate Fowler, Mr. Chairman, I would say to the delegate, it's provided by the tenant, and it's got to be an insurance policy from a provider that's licensed by the Virginia State Corporation Commission. So this would be a line of insurance that would have to be offered, and here in Virginia by a company licensed to do business in Virginia that would be really for this purpose. So they develop a line of insurance, which would be insurance in lieu of a security deposit.
Mr. Chairman?
Yes, Delegate Fowler.
A follow-up question. With this policy, like most of these insurance policies for homeowners, obviously have rather large deductibles. Can you shed any light on that?
Yeah, so, Mr. Chairman, I would say to the delegate that, no, this wouldn't have a deductible. I mean, the idea is that this would essentially simulate a security deposit. So the payout would have to be the loss payee would be the landlord. And so in the event of a loss, the landlord would make a claim on the policy, and it would have to guarantee the landlord a coverage of up to whatever they contracted for, I guess, so, and then not in excess of 2 months. Sometimes it may be a month, if that's what the landlord wanted to contract for. So you've got to provide a policy that guarantees me a payout of 1 month's rent, but it could be up to 2 months' rent under the Act.
I think
Chairman, one
Chairman.
moment. Delegate Torian.
Mr. Chairman, I have a motion. Can we pass this by for today?
We'll get these questions again.
And give the patron an opportunity to come and present his own bill.
Right. So, Mr. Chairman Torian, maybe we could do that pass by temporarily and put it at the end, and then if we get to the end, then we can do pass by of the day. Okay. There's been a motion to pass by temporarily. All those in favor say aye.
Aye.
All those opposed. All right. We passed by that one temporarily. All right. Delegate Simon.
I thought I was doing pretty good, Mr. Chairman.
You are doing good.
House Bill 1408 is from Delegate Rush. And this is Delegate Rush isn't here, and this one's actually fairly controversial, so we may want to take this one by temporarily as well. But maybe we'll give it a shot. This would designate cornhole as the official tailgate game of the Commonwealth. And I would say to the committee that this had an interesting procedural history. It initially failed appropriately by a vote of 3-3. But someone felt soft and wanted to reconsider their vote. And so upon reconsideration, this bill was recommended for reporting by a vote of 3-2-1.
Delegate Simon, you just jogged my memory that Delegate Rush asked if we could pass this one by for the day. And that was his request.
Well, did you have Mr. Chairman, did he have your admonition that may mean it doesn't get back on the docket?
I think it'll get back on the docket if he wants it. All right, but he did request it to go by for the day. Do I have a motion?
So,
Is there a second?
Second.
All in favor say aye.
Aye.
All those opposed. All right, that
No.
one's by for the day. Delegate Simon.
Delegate, Mr. Chairman, members of the committee, House Bill 1514 from Delegate McQuinn makes a change to the Virginia Human Rights Act and provides that the term because of race and on the basis of race in terms of similar import when used in reference to discrimination in the Code of Virginia and acts of the Virginia General Assembly includes traits historically associated with race, including hair texture, hair type, and protective hairstyles such as braids, locks, and twists. And this bill was recommended by the subcommittee for reporting on a vote of 7-1 without any amendments, and I would so move.
Very good. Delegate Miaris, did you want to speak to this one, or is that your light on from before? Okay. Is there any discussion from the committee? Hearing none, is there any member of the audience who did not have a chance to speak in subcommittee who wishes to speak to the measure? Hearing none, the clerk will open the roll. All right, clerk, close the roll. That bill reports 16-5. Delegate Simon.
Mr. Chairman, the next two bills on our agenda are in the category of bills that need to be reported and referred to appropriations if we act favorably upon them. The first of those bills is House Bill 827 from Delegate Carol Foy, which requires employers, as defined in the bill, to make reasonable accommodations for the known limitations of a person related to pregnancy, childbirth, or related medical conditions, if such accommodation is necessary to assist such person in performing a particular job, unless the employer can demonstrate that the accommodation would impose an undue hardship on the employer. It also prohibits employers from taking any adverse action against an employee who requests or uses a reasonable accommodation, and from denying employment or promotion opportunities to an otherwise qualified applicant or employee because such employer would be required to make, because the employer will be required to make reasonable accommodations to the applicant or employee. And the bill creates a cause of action against any employer who denies any of the rights afforded by the bill. There was a committee substitute which adds language that provides that nothing in the language of the bill shall be deemed to alter, supersede, or otherwise modify the authority of the Division of Human Rights or any local human rights or human relations commissions. So I ask, at this point, I guess I could get a motion on the substitute.
Okay.
So moved.
All right,
Second.
it's been moved and properly seconded. All those in favor of the substitute say aye.
Aye.
All those opposed?
And with that additional language in the substitute, the subcommittee recommends reporting with substitute and referring to appropriations by a vote of 7-0, and I so move.
Okay. Is there any discussion among committee members? Is there anybody in the audience wishing to speak to the measure who did not have an opportunity to speak before the subcommittee? All right, hearing none, clerk will open the roll. All right, clerk will close the roll. That bill reports and is referred to appropriations on a vote of 19-2. Delegate Simon.
Mr. Chairman, members of the committee, the next bill in that category is House Bill 1663, and to which we just rolled those 7 bills that I spoke about earlier.
Delegate Simon?
Yep.
If I could have you suspend really quickly, I see that Delegate Keem is here. Delegate Keem, do you need to be any place, or you okay hanging out for a while?
There's no place more important than right here. None.
Aw.
We'll come back to you.
All right, we'll come back to you. Delegate Keem, that was sweet, but that was so the wrong answer. Delegate Simon.
Mr. Chairman, members of the committee, House Bill 1663 is our comprehensive anti-discrimination bill. It creates explicit causes of action for unlawful discrimination in public accommodations and employment in the Virginia Human Rights Act. Currently, under the Act, there's no cause of action for discrimination in public accommodations, and the only causes of action for discrimination in employment are for unlawful discharge on the basis of race, color, religion, national origin, sex, pregnancy, childbirth, or related medical conditions, including lactation, by employers employing more than 5 but fewer than 15 persons, and unlawful discharge on the basis of age by employers employing more than 5 but fewer than 20 persons. This bill allows the causes of action to be pursued privately by the aggrieved person or in certain circumstances by the Attorney General. The bill prohibits discrimination in public and private employment on the basis of sexual orientation and gender identity. The bill also codifies for state and local government employment the current prohibitions on discrimination in employment on the basis of race, color, religion, national origin, sex, pregnancy, childbirth, and other related medical conditions, age, marital status, disability, or status as a veteran. Additionally, the bill prohibits discrimination in public accommodations on the basis of sexual orientation, gender identity, or status as a veteran, prohibits discrimination in credit on the basis of sexual orientation, gender identity, pregnancy, childbirth, or related medical conditions, disability, and as status as a veteran. And C adds discrimination on the basis of an individual's sexual orientation, gender identity, pregnancy, childbirth, or related medical conditions, marital status, or status as a veteran as an unlawful housing practice. However, the subcommittee recommended adopting a substitute which removes pregnancy, childbirth, or related medical conditions and marital status from the provisions of the bill that fall under the Virginia Fair Housing Law. The reason for that being that those classes are covered under very specific definitions in the Fair Housing section related to familial status. Familial status already includes those definitions, and we thought that was well covered there and didn't want to introduce new language in the Fair Housing statute where we already had a pretty good body of law on those issues. And so I would take a motion, I guess, at this point on the substitute. I'll move the substitute.
Okay. It's properly moved and seconded. All those in favor of the substitute say aye. Aye. All those opposed? Delegate Simon, I believe there's also an amendment to the substitute.
And before we get to the recommendation, there was the substitute. The other thing the substitute did was allow for administrative subpoenas by the Attorney General's office, and that was at the, for those of you that were there at subcommittee, sort of a last-minute, late-night addition. I realized that a lot of the stakeholders had left the room and suggested that if that wasn't a consensus item, that there may be a further recommendation at full committee to remove that language. And the way things played out, that is in fact, I think, the desire of all the different stakeholders, that that's not a consensus item. So I have a motion. I'd like to move an amendment that we strike lines, I wrote them down. Give me 1 second. Lines 48 through 74 of the bill. And what that does, by striking lines 48 through 74, that takes out the provision that allowed the Attorney General's office to issue administrative subpoenas to enforce the bill, which upset, again, not upset, but was contrary to the will of some of the folks that previously endorsed the bill. And so to keep this consensus, understanding the Attorney General's office gets a couple more bites at this apple before it becomes law, I would move that we strike those lines from the substitute.
Okay, there's been a proper motion. Is there a second?
Second.
All right, does anybody have any questions about the amendment? All right, hearing none, all those in favor say aye. Aye. All those opposed.
And Mr. Chairman, with the previous language, and then I think with an understanding that the language that we just struck might come out, it was still the subcommittee's recommendation that we report and refer to appropriations, the bill as the substitute as amended on a vote of 5-1, and I so move.
All right. We have the patron here. Do any members of the committee have any questions of the patron or any discussion? Is there anybody in the audience who did not have a chance to speak in subcommittee that wishes to speak at this point? Hearing none.
Move to report.
Second.
All right, hold on 1 moment.
Sorry. My name is Becca Saxon. I'm with the Virginia Education Association. We support this bill.
All right, thank you. All right. Clerk, open the roll. All right. Clerk, close the roll. That bill reports and is referred to appropriations on a vote of 15-6. Delegate Simon.
So, Mr. Chairman, that would conclude my report, except that we took by temporarily Delegate Keem's, I think very well explained already, Bill, but so House Bill 1333, once again, we were discussing this, Delegate Keem, while you were gone, sure. Mr. Chairman. There were some questions about the coverage and whether it would have a deductible or not. My description of it was that it wouldn't have a deductible because it has to guarantee coverage to the landlord. I don't know if there were further questions, but that's where we were. That's where we left off before you came in.
Okay. Delegate Cole.
Yes, thank you, Mr. Chairman. I've been contacted by a couple of landlords that state that this will put a unfair burden on them, and I'm just trying to understand, is this something that is permissive? Does the landlord have a choice on whether or not they take a security deposit or offer the insurance, or is it required that they have no choice? It's up to the prospective tenant to pick which they prefer.
Mr. Chair, in answer to the delegate from Spotsylvania, if you look at this, I guess we're now looking at the substitute since that's what's before you. If you look at lines 32, 33 on the substitute, the existing language of our code right now says a landlord may collect a security deposit, and so we're already starting with permissive. So the current law is that landlord may, and then if in an amount or require damage insurance coverage for an amount or any combination thereof. So if the landlord chooses to do security deposits, that's already a permissive matter, then they can choose to do it either as, I guess, cash, if you want to call it that, cash, damage insurance, or a combination. So it really is a permissive matter.
Delegate Cole.
Yes, follow up. However, on line 246 of the bill, it says the landlord shall permit a tenant to provide damage insurance coverage in lieu of payment. So that seems to make it a requirement that the insurance be provided rather than an option.
Mr. Chairman, to answer the delegate, I think the way this would work is that for landlords that do require security deposits, we don't want them to discriminate based on how they do that. If they don't want to receive security deposit at all, then it's up to them. So if they are going to do it, then we have now a combination of cash insurance, or both. Now, if a tenant chooses, this is a choice on both sides. If the landlord chooses to accept security deposit, then he should offer it he should accept it in a way that's amenable to all those combinations. If the tenant chooses to accept the insurance, then at that point the insurance has to meet the certain criteria. So that's the way the language is written, and that's the way I envision this would be working out. As landlords and in that community would look at insurance opportunities and say, these are the insurance companies I'd like to work with, and then offer that as part of the options to the tenant.
Delegate Mayaris.
I guess my question, Delegate Keem, is why is this bill needed? Since this is a provision of the code that says may, correct me if I'm wrong, but there is nothing today. I can go out right now if I'm a landlord and I could decide I don't need a security deposit, or I could decide in lieu of a security deposit, I want this premium for an insurance coverage deductible. And there's nothing right now in the code that prevents this from happening right now. Why do you think your bill is needed, since the entire section of the code is a may, not shall?
Mr. Chair, I'd answer the delegate from Virginia Beach that the reason why we're doing this is to protect future consumers. Right now, you're absolutely right that the code does not require a security deposit to be made, although the common practice now, I don't know of a single landlord who would say, just move in without any kind of security. So it's already a practice. The code allows it as a permissive. Now, the real issue is if they were to go out to the marketplace and say, hey, I'd like to accept insurance right now for damage control by renters, not the renter's insurance, but damage insurance based on the security deposit, then any fly-by-night company can come in here, and I'm actually sitting in the Labor Commerce right now dealing with these payday lenders. Any company can come in and say, I'll offer that. I'm a fly-by-night. I have no presence in Virginia. I have no license, but I'll just offer that to you. And that landlord could possibly, and the tenant could possibly be signing up with a contract with an insurance company that has no legitimacy whatsoever. What this does is it safeguards the consumers by having lists of the conditions, including the licensing before the SEC, all the conditions of how much coverage ought to be protected. So I see this as, if this were to happen, we want to make sure that the government is there as a backstop to stop the bad actors from acting. So I see this as a consumer protection law.
Mr. Chairman.
All right, Delegate Krizik.
So, Mr. Chairman, question for the delegate. So I kind of walk me through this a little bit. I'm a little unclear. So you have a policy, that's been agreed upon, and it's in lieu of a normal, deposit of a first and last month or whatever. So is the policy that you show to the landlord, if you're the tenant, is that going to show that that's paid up policy good for X number of years or 1 year or however long the lease is? Or is it a policy that shows that you've got insurance but that you're going to be making quarterly payments on the insurance or something like that?
Mr. Chair, I'd answer the gentleman. If you want, and I'm sorry this might take a long time because in order to answer your question, I think we need to think through step by step. First step would be if a tenant and the landlord would agree that this would be an option for them, then you'd have to go to an insurance carrier that offers this product. There are a few right now in the country, Virginia, because we haven't allowed this yet. There are no products in Virginia yet, but the Bureau of Insurance tells me that if they were to come through, they have a licensing mechanism in place. So if they choose that, what we envision is the landlord is the main player here. They are the ones that will be protected, not the tenants. The landlord is protected because this is security deposit for the landlord. This has nothing to do with tenants protecting their products in their home. I mean, we're familiar with renter's insurance. This is not renter's insurance. This is landlord using security insurance to protect themselves from the event that tenants destroy their property. So what would happen is, at the moment that an insurance is signed, the amount of coverage has to be at least the same as the security deposit they would normally accept, maybe even more, maybe up to $10,000. And then the premiums would be paid by the tenant in order to provide the beneficiary of the landlord. So if the landlord says, hey, I just saw that you've damaged my refrigerator in your apartment, I need to fix that, at that point, the landlord would call the insurance company. The insurance company would come in and repair that, so the landlord is left with no risk whatsoever.
Mr. Chairman, follow-up question.
Delegate Krizik, and we'll need to move this along.
Okay, I'm sorry. I was fine with everything until you said paying the premiums. My concern is, what if a tenant doesn't pay the premiums and then that insurance is no longer protecting the landlord?
Mr. Chairman, I would answer the gentleman that the premium is part of the contract that he or she will sign as a tenant. That having, just like if you miss a payment on a monthly payment, let's say I rent an apartment and I don't pay rent, you're evicted. So it would be the same thing. It's like having insurance for the purpose of you getting the apartment. So if you don't pay the premium, then you should not belong in that apartment. This is to protect the landlords.
I'm sorry, but I got to ask one last question.
one
I'm sorry,
more,
Mr. Chairman.
Delegate.
So how will the landlord knows when you don't pay the rent, but how will they know that you didn't pay the premium?
Mr. Chair, Delegate Krizak, if you read through the line by line of the conditions, that was designed to provide the landlord with all of those safeguards. And so if there's something that's missing here, if you want the landlord to require a photocopy of an insurance premium, something along those lines, I'd be happy to add that because that would be in the spirit of this bill, which is to protect the landlord.
Okay, well, let's see where we go. Delegate Simon.
Yeah, so very quickly, the way this would work is that somebody will agree. Somebody's going to run an $800 a month apartment, and they don't have $1,600 up front to put down for a 2-month security deposit, but they can pay $815 a month, right? So you're going to charge them $815 a month. You're going to take the $15 that's over the $800, and you're going to use it to pay the insurance premium because you're the landlord and you're the beneficiary of the premium. You're going to make them choose from a list of insurance providers that you approved because it's right here. You can set a limit of who's approvable. So you already have control over the company is. You have some history with them. You take the money in. So it's a way for somebody to offer relatively affordable housing without making that initial upfront payment a barrier. And that's how I'd say it worked. I think it's a good bill. I move that we support it and pass it along.
All right, so we got 2 more in the queue, and then we'll wrap it up. So Delegate Van Valkenburg and then Delegate Knight.
Popular guy.
Thank you, Mr. Chairman. Mr. Chairman, Delegate Keem, I feel like I'm a little slow here, but I want to kind of go back to Delegate Miyares' point. We're kind of toggling back in the language between whether it's a may or a shall, and so I just want to pin that down because we're saying, so if you're a landlord and you choose to take in the security deposit, you then have to either you take a security deposit or the insurance. You don't have a choice. Is that clear? Is that
Mr.
right?
Chair, I'd answer the delegate. That's the way the bill is written right now.
Thank you. Delegate Knight.
To piggyback on what Delegate Van Valkenburg said, he's exactly right. If I'm a landowner, I have a house, you come to me, you say, I would like to, rent this, and I say, fine. And you say, oh, by the way, now you don't have a choice. I'm going to do this insurance. Then maybe the tenant was to skip out. When the tenant skips out, they tore up my house. I now go back to the insurance company and say, I want to make a claim. Instead of having instant money, now I have to go in there and prove. The burden of proof is now on me. I don't want to rent that person the house. So kind of to cut to the chase, I could support this bill if on 246 you would change the shall to a may, and you would have a lot of protections in there with your insurance company, but that would make me feel very comfortable.
Mr. Chair, I'd answer the delegate by saying that was always the intent. The way the language was written that way is because what we're saying is right now the landlord doesn't have to accept it, but if they are going to accept it, let's do it on a level playing field. So the landlord can't say, I'll do it, but I'll never, ever accept that insurance ever again. So we want to be able to have some opportunity and incentives for that.
So Delegate Keem, if I could, because, so the whether or not to ask for that security deposit as a may on behalf of the landlord, I think what you're saying is that so once that may has been executed, that the person who's moving in shall be able to do that vis-a-vis a security deposit or insurance. And so I guess what Delegate Knight is saying is whether or not you want to put that may in there, which would then quite honestly leave it up to the landlord about whether they want to go that route. So I don't know if you want to do that now or come back and work on and think about it.
I could deal with it either way. I'll leave it up to the pleasure of this body. I've already trespassed on your time too much already, but I'm happy to do whatever it takes to answer every question. So I'm happy to do whatever you want.
So what I would prefer to do, if it's okay, and I realize our time is short. I hate to force you to make decisions like that on the fly.
I make a lot of bad decisions on the fly, so that's okay.
All right.
No, I'm happy to make it from a shell to a may if that helps you. But
Delegate Knight?
I would like to make an amendment to on line 46 after landlord change the shall to a may.
Okay. Is there a second to that?
Second.
All right. Is there any further discussion? Everybody understand what we're doing? Okay. All those in favor of that amendment, say aye.
Aye.
All those opposed?
No.
No.
Okay. All right, so we have the bill as amended before us. Any further discussion? All right, clerk, open the roll. All right, clerk, close the roll. That bill reports with a substitute, 18-2. Thank you, Delegate Keem.
Just to clarify, substitute with the amendment.
Correct.
Right? Okay,
Yes.
Just want to make sure I clarify. Thanks. Thank you, Mr. Chairman.
All right, thank you. That was great work. We got a lot of bills out today. We still got a lot more to go. And so for those of you who are watching, we've got our Open Government and Procurement Subcommittee that will be meeting 5 minutes? Yeah, 4 o'clock. They have a busy docket, and so they're going to need their full 2 hours. And so if you're here for ABC Gaming, that will start at 6 o'clock. Do I have a motion to adjourn?
So moved.
Is there a second? All those in favor say aye. All those opposed, we stand adjourned. Thank you.